Good morning, late morning. We're now starting a session called The Lure of the BVI, the British Virgin Islands. And it's my pleasure to moderate a conversation that we're going to have with, to my immediate left, Bomi Anise, who lives in the BVI, who spent 10 years as a lawyer in the London D&O, or Directors and Officers Liability Insurance market, advising insurers, dealing with risks, dealing with directors who sometimes get things wrong. And then the last 8 years in the BVI, she's been running an advisory or consultancy in the area of regulatory compliance for regulated trust companies in the BVI, due diligence advisory work. She's also advised funds, hedge funds, on compliance. She also helped to set up and co-manage a new trust company which had ownership from Russia for 3 years. She's also the chair of the Education Committee for the BVI Association of Compliance Officers. So we have someone on the panel with deep understanding of the issues in play dealing with regulation and compliance in the BVI. Andrew Bodner is a colleague and a barrister from London with Matrix Chambers, been a barrister for 20 years. Matrix is well known for international human rights work, privacy, media, information defamation, but also in Andrew's bailiwick, fraud, asset recovery, asset tracing. Andrew's also a co-editor with Smith, Owen, and himself in a Oxford University Press, the leading loose-leaf publication on what I call criminal asset recovery, meaning POCA, Proceeds of Crime Act, the public law version of asset recovery as opposed to private law or victims with private lawsuits. He is also in Dubai quite a bit right now in the DIFC court working on a fraud case. So I think having a voice from outside the BVI that is familiar with some of the issues that we address in terms of regulation, compliance, and law in the BVI is very helpful to address our subject matter. Now I'm just going to move over here and we're going to have the conversation. In contrast to individual lectures, and we're going to flow through our material. The first, actually, we may have skipped one slide somehow. There we go. We're going to look at some basic statistics to give you some frame of reference or context for what we mean by the offshore financial or the financial services center in the BVI. Of course, some would say in simple terms that for smaller jurisdictions that provide financial services, it used to be said Bermuda was king of insurance offshore, Cayman king of banking offshore, and BVI was the king of companies. And I think that may still be the case. So I learned that little phrase 20 years ago, and I don't think it's really changed that much over the last 20 years. We now have, as of the end of last year, almost 460,000 active companies registered in the BVI. And to put that in context, there are about 2 million so-called offshore companies in the world. And so we represent about 25% of the population of the world's offshore companies as a place of domicile, a place of incorporation for those companies. I would say that, though I would hazard to say that the aggregated value of all of the balance sheets and the assets reposed on our 460,000 vehicles would be greater than 25%. I think it's a dark number. We don't know if it's 40%, but I would dare say it's more than that because so many substantial holding companies are domiciled in the BVI. We have, it also should be noted that, the debate about what is offshore and what is on gets all muddled and confused. There are no straight lines. It's blurred. Delaware has 800,000 plus companies, and they're not amongst the so-called 2 million offshore companies, and yet you could sensibly argue that many of those Delaware companies are more akin to what we see in the BVI or Cayman than what we see in a traditional onshore jurisdiction, like you would think of Delaware. Although it must be said that 60% of all public companies in America, big public companies, are domiciled in Delaware, so we can't forget that we can categorize Delaware as exclusively an onshore, offshore jurisdiction, because it's not. It has many, many large balance sheet, active trading companies on the New York Stock Exchange in Delaware. One of the interesting parts we're going to get into is how regulation of these companies in Delaware, how you might juxtapose those with those rules, which I would argue are non-existent compared to what we have in the BVI. We have 2,000 or so hedge funds registered in the BVI, which I think is a small proportion of, if you compare us to Cayman, we have a smaller portion of that market. Over $125 billion invested through BVI companies annually, globally. This came from, I think, a Withers report in 2013. I should suggest that that would be inward investment that you could tally up by looking at inward investment statistics from Russia, China, etc. I think that's where that number comes from. And I say that does not include retained assets on balance sheets. This is just flows in 1 year. So ergo, I maintain there are trillions of dollars of value notionally, in legal terms, parked onto the platform of these aggregated 460,000 vehicles. So it's a huge proportion of the world's private wealth. No one knows what proportion. It's a dark number again, but it is big. We have the second largest source of international foreign direct investment globally. So as I say, if you go to the website for the Russian Federation, BVI will be listed in the top 2 or 3 usually, or China as foreign investors, or a source of foreign investment, I should say. Next. Tax neutrality. When we're talking about the lure of the BVI to these companies, to the formation of companies and their use for commercial purposes, the first thing that comes to mind is what I call the plumbing of globalization. So the idea that you can have legal constructs or artificial legal persons called company that can and are used to efficiently move capital from developed nations to developing nations, for instance. And one could argue that without this plumbing, this infrastructure, providing tax neutrality and efficiency, a good deal of the positive consequences of globalization in BRIC countries, in Brazil, in South Africa, China, Russia, over the last 15 or 20 years would not have been as expansive and generous absent the pipeline of moving capital tax efficiently. So we don't have business or corporations tax in the BVI. We have no stamp duty on the transfer of assets except for real estate that's sightest in the British Virgin Islands. And we now have, I guess, transfer pricing offshore. I will move it over to Andrew.
Well, actually, before we continue, I'd like to sort of add something to what you've said, Martin, and which is, I mean, if you look at BVI structures and how they tend to be used, you on the international forum, you have parties who aren't necessarily from the same jurisdiction. So you might have a Russian who does business, who's seeking investment from UK nationals, or joint ventures of that nature. And I think because of all of the complexities, as soon as you start to get different players from different jurisdictions, I'm not a tax lawyer by any stretch of the imagination, nor would I ever want to be, But the complexities that arise when you have nationals and companies and joint ventures in various jurisdictions means that I think there is a market to search for a place which is tax neutral, that allows people to actually do the business at hand, grow the economy, have a joint venture without, say, a UK national then all of a sudden being subject to Russian tax. And so those are some of the uses as well that we kind of see in terms of that tax neutrality for actual joint ventures and corporate structures in big deals.
Andrew, what about transfer pricing?
Transfer pricing is a topic which we may not be discussing this time next year, of course. Does everybody in the room know what transfer pricing is before we start? If anyone doesn't, it's a simple process of, for example, digging oil out of the ground in sub-Saharan Africa, but selling it, for example, through a BVI company, so that the profits stay in the BVI rather than in a inherently risky jurisdiction where a sudden voluntary or otherwise political change might lead to your profits being seized by the state. Might be a good example of why you might do it.
Or if you're making children's toys in China and you want to pay less tax in the United States, you might, if you're trading in those toys in the United States, you might sell the toys first to a BVI company at a large inflated price, and then your tax basis in the sale of the toys in America might be higher than it otherwise would be. So you park artificially, some would argue, taxes in BVI, but it's perfectly lawful to do that. Yeah. And I think some first world nations are starting to criticize this whole model.
That's the point. Transfer pricing is an OECD approved method of moving money around from one jurisdiction to another. And as Martin says, it's not always because there's a very good reason why you wouldn't want your profits to stay in a particular country. It might simply be for tax efficiency reasons. And probably it's going to come to an end fairly soon. I think the OECD, at the moment there's an OECD guidance which is about, half an inch thick to an inch thick, about what is acceptable as transfer pricing and what is simply a sham transaction, which is tax evasion. And governments around the world are starting to recognize that it's not perhaps the best way to maximize tax revenue from corporations.
I think the core point about this slide, tax avoidance is not tax evasion, is really has to do with the reputational criticisms that jurisdictions like the BVI sometimes receive from first world nations, that there seems to be a tendency when the BVI gets criticized in the Guardian newspaper on this subject to merge avoidance and evasion as one thing. And this concept of avoidance, which is perfectly lawful, and the taxpayer has no obligation to pay taxes unless the law requires him to do so, that's the law. And that concept is alive in London, in Canada, where I'm from, all over the world. So for newspaper journalists to merge the two and just say everything is bad in the BVI dealing with tax evasion / avoidance, I think it's really muddled and confused.
I'll give you an example. London, I'm not going to get into whether it should be doing it or not, but London attracts ultra high net worth individuals from around the world for the purpose of trickle-down economics, if nothing else. We'd like to have the world's elite in London in the hope that it'll benefit the UK economy. Now, let me give you an example. I'm not a tax lawyer, but this is a simple piece of tax. Suppose I'm an oligarch and I wish to buy a £100 million house in London. They've become a big issue. If I wish to do it with my own money, even though I'm non-domiciled for tax purposes, and to buy the house in my own name, I need to bring £100 million onshore, which means I need to pay tax on £100 million. I then also need to pay stamp duty on buying the house, which currently is 12%. So I need to give the UK taxman another £12 million, and I need to pay the tax for bringing the money onshore to give to the UK taxman. So overall, to buy a £100 million house, I need to make available somewhere around £210 million. If, on the other hand, that house is owned by a BVI company, and I buy the BVI company without the house ever changing ownership, I don't need to bring a single penny onshore into the UK, and I pay £100 million. let's be honest, you'd have to be a congenital idiot to not use the BVI structure.
And both are legal.
And both are perfectly legal. And if you're the chief executive of a public company, and you have two ways of doing something, one of which will yield a tax bill of maybe 10%, and another of which will yield a tax bill of 30%. If you choose the one that yields a tax bill of 30%, are you not acting contrary to the interests of your shareholders by doing it?
And will your shareholders not then sue you?
And your shareholders
your
could
own
probably
duties?
sue you for it. In Swiss law, for a long time, it was actually an offence for a director to choose the more expensive option. So it's very important that tax avoidance is not tax evasion. And if governments around the world wish to change the system, they need to change their own tax laws. Rather than demonizing the BVI, I think.
Absolutely. And I think actually, we all know where things are going with FATCA, UK FATCA. Sort of Russia has a draft legislation on the books for
De-offshoreization, they call it.
But no, that specific one called Russian-controlled foreign corporations law that deals specifically with those who own offshore companies. And one draft I hear says specifically it will be a crime if you own any sort of foreign-controlled corporation. Another says you just have to declare it, so very FATCA-esque, if you will. Ironically, trusts are excluded. But we can talk later about why that may be. But, I mean, the whole point is that under the law, whether it's in the UK or sort of elsewhere, it is a generally accepted legal principle that one can structure one's own tax affairs to mitigate their tax liability. In the same way, very pedestrian, if you see a designer bag for $1,000 and you see the same designer bag on sale because it's last season's model for 50% off, are you going to pay full price for it? Probably not. And so I think we have to be careful when we sort of, as Martin says, lump everything together that, tax avoidance is bad. People are doing mostly what people do every day in every context. It just so happens that a lot of times there are millions of dollars at stake. And if governments do want to then change that, what is now legal, then they change it. And that's what we're seeing more and more.
Now, there was some criticism in the 1980s and 90s, obviously, when the old principles of public international law still were generally, with the exception of warfare, honored, meaning that jurisdictions like the BVI would be respected in terms of their sovereignty, so that we would not, in the 1980s or 90s, necessarily cooperate with criminal tax evasion investigations going on in the United States or Canada or Britain. That is changing very, very substantially. And so the thesis is that the smaller jurisdictions, by virtue of pressure being applied to them by first world nations, are now having to change their approach to what was a traditional, respected, and understood notion of sovereignty. There was nothing wrong for smaller jurisdictions to decline to participate in revenue investigations because there is an old principle in English law and in public international law that the revenue and penal laws of foreign lands are not capable of being recognized or enforced locally. So it wasn't, and the BVI didn't create that principle. It came from developed nations as a way to resolve conflicts that can arise, that can cause big nations to go to war, is you have to respect each other's sovereignty. That was the idea. So there was nothing the BVI did that was wrong before the current pressure that's being applied to compel or coerce some form of cooperation in tax crime investigations. So Bomi, what do we have now as a result of this international pressure? to change the old rules that the developed nations created?
Well, I mean, I would say, first of all, I mean, let's go back to common law principles. I mean, there's a case, Government of India versus Taylor, which is a UK decision, which effectively says that foreign tax laws are not enforceable in the UK. So if you are an American who, who breached IRS rules and filings, and you have some assets in the UK, and the IRS wants to come after you, they go to the UK and attempt to get you there and get your assets. The UK is, under that principle, is not required. That's not a BVI thing. That is a principle under UK law. Obviously, things have moved on now in terms of where we are post-global financial crisis, and we're sort of much more into the realm of mutual cooperation. I mean, I still believe it is each country's duty and obligation to go after its own citizens or residents, however it decides to tax them, to actually get the money they're due to pay. And so I don't believe that BVI is actually a global tax collector. That said, the BVI is very, very keen to and is already engaging in a lot of international cooperation. It has signed tax information exchange agreements with 27 countries, including China. The agreement with China was concluded in December 2010. And you also, the BVI is also party to the Multilateral Convention on Tax Matters. It's signed FATCA. So as of June 30th, 2014, FATCA came into effect effectively in the BVI. People are getting GIN numbers, they're signing up. I mean, it is a hot topic of compliance in terms of what to do, registration through the BVI, and the passage of that information to the US. The BVI has also signed an intergovernmental agreement with the UK, what we tend to call UK FATCA. That came into effect November 2013, and we're also a member of the Egmont Group, which allows, again, for cooperation should there be the need for either criminal investigations or tax matters.
Those are, it's a slightly different, Egmont Group gets into an interesting area of the sharing of intelligence on a rapid fire basis, not 24/7, because governments don't open 24/7, like some law firms have to, but that from Monday to Tuesday, Wednesday to Thursday, Friday, an Egyptian anti-corruption investigator in Cairo who is investigating companies linked to, say, former President Mubarak, could send through a secured email message in the Egmont Group's computer. And I think the computers are in Madrid or in Spain, and the secretariat for the group is in Toronto, as I recall. And this message just goes right to the BVI, to the Financial Investigations Agency, I believe, and is processed quite quickly. I was asked by the World Bank to go and speak to some senior anti-corruption officials in Cairo, so I actually have some knowledge of how this works. Before I did that, I asked the FIA's head for advice on how long it takes to process Egmont Group requests, and he says 2 or 3 days. They're able to go down to the local trust company, gather information, note it down as to who is the beneficial owner of a company that is the subject of anti-corruption investigation dealing with, say, former President Mubarak, and then convey that data into the system, and it's electronically passed instantaneously to Egypt, and on it goes. So that really helps in international criminal anti-corruption, anti-fraud investigations between states. So we're talking public law, not private law or private victims' rights. That's a whole different thing. This is much better for investigations than the MLAT process, which is the lumbering, slow process of gathering evidence for criminal trials, and it can take much longer to gather evidence that way. So,
I mean, that said, just to put again into context, numbers that we're talking about and how the landscape for exchange of information has changed. According to the BVI's International Tax Authority, in 2012, there were 87 TIA requests, tax information exchange agreement requests. That went up to 397 in 2014. And in 2015, thus far, there have been 258. So I mean, we're definitely getting into a changing landscape. And what I also find interesting anecdotally is if you remember the first slide, there's sort of nearly 430,000 odd BVI companies. It said that effectively incorporations in the BVI are still up back to near where they were pre-crisis levels, economic crisis levels. And that is still with all of this knowledge that there is going to be tax information exchanged. So if you're doing something dodgy, you will be caught. So the inference one draws from that, at least that I draw from that, is that the BVI companies are actually used for legitimate business purposes because there are mechanisms in place to...
Predominantly.
Wow. Yeah, companies around the world, all companies around the world, some companies around the world in all jurisdictions can always be used for fraud.
The Cypriot sandwich. We like sandwiches. Why do we have the Cypriot sandwich, Bomi?
One of the things that's obviously, again, we're talking about the lure of the BVI, right? So, and it's definitely perceived that both the Russians and the Chinese like to use BVI companies. So why is that? There must be a reason. A lot of times they previously wouldn't just use BVI companies. What they would do is have a Russian company that trades aluminum or manufactures beer or whatever else. And that would be a standard operating, trading Russian company. Because of double taxation treaties that actually are in existence with Cyprus, it provides favorable tax treatment to Russians. And so any capital gains received by a Cypriot company for the sale of shares in that company are not subject to tax. So all of a sudden the Russians say, oh, that's a great idea. So they then would have the Russian company owned by a Cypriot company. Now, with that, you have either for dividends that are issued by that Cypriot company, if you've actually invested greater $100,000 or more of capital into that Russian company or Cypriot company of $100,000 worth of assets of capital that you've contributed into that company, the actual withholding tax on dividends was 5%. If it's lower than, if your investment is lower than $100,000, it's 10%. A lot of times what people would then do is on top of the Cypriot company, you would effectively then have a BVI company. So the Cypriot sandwich would actually be, the BVI is sort of in there.
Bomi, in Cyprus, I believe, the identities of shareholders of Cypriot companies are registered in the public registry. Do you recall that might be the case?
Yes, that is true. You can get that information.
So if you have a Russian or Ukrainian business that's owned by a company in Russia or Ukraine owned by a Cypriot company, which is a typical structure for the reasons Bomi's just explained, you can go to the public registry and see who is the shareholder of it. And oftentimes we find the BVI companies are registered as the owners of the Cypriot companies owning ultimately Russian or Ukrainian assets. What happens when we go to the share register in BVI to find out who owns the ultimate ownership of the Russian or Ukrainian business?
Well, I mean, the share registers in the BVI, I think Craig hopefully said this yesterday, share registers and directors' registers are kept by registered agents in the BVI. So as we all know in the public debate, there is no central registry, public central register of beneficial ownership or shareholder information. However, that information is required to be held by registered agents.
So we'll come back to that a little bit later, but when we're talking about the Cypriot sandwich, from a fraud investigator's perspective, there's a little bit more work we have to do in the BVI to find out what's behind the ownership of the sandwich. Is BVI a scapegoat? Well, yes. It gets hammered, it gets criticized all the time. It's a small place. We only have 22,000 people in Tortola, 32,000 or so in the islands, in the territory. We're a small population, and yet we have a larger impact than our size, disproportionately larger impact than our size in the world's economy in terms of this infrastructure I talk about, or plumbing for globalization. And it's very easy to pick on a little guy and kick him around for political reasons. I have a brother who happens to be a politician, and I know politicians enjoy speaking in a popular sense, and it seems easy in London for politicians to say, oh, it is embarrassing that we have these former British colonies, now called territories, relics of the British Empire, involved in some kind of shady or shadowy business dealing with perhaps revenue offense concealment or fraud and other abuses of this thing called company, without regard for looking critically at the problems at their own feet with their own company's registry and the abuse of companies locally. And it's very simple for the reason why politicians criticize smaller jurisdictions is it's an easy way to gain some more popularity in elections, and there's nobody responding. There's nobody coming back and creating a political cost for exaggerating facts, for fear-mongering, and for getting the debate wrong or in an unfair or imbalanced way. So I think it's important that, of course, smaller jurisdictions like the BVI have reason to be on guard and reason to be regulated and to regulate people in the administration of wealth, which is what we're talking about.
Martin, I've no idea whether it's true or not. I should preface in a session which is being taped and will be published on the internet. May or may not be true, but it is an apocryphal story that's told about some decades ago in Jersey, when the UK government kept coming under pressure with the tax efficiency going on, allegedly, in Jersey at the time. And the story runs that every time the politicians said, we must have full disclosure of every Jersey bank account held by a UK citizen, the banks in Jersey would phone the politicians and say, you do mean every account, don't you? And the investigation would die a death. As I say, I have no idea whether that's true or not, but that might be an example of a political cost that can be extracted.
So I would flip it over, this debate, on its head and suggest that because of what's happened in the last 20 years, we go back in time. My thesis is that the regulation of smaller jurisdictions like the BVI is tied directly to the history of the introduction of the ancillary crime called money laundering. It wasn't long ago when we didn't have this as a crime. It was in the 1980s when, under the Reagan administration, narcotics trafficking proceeds, concealing the proceeds of narcotics trafficking was the limit of what was known as money laundering in that era. And then, starting in 1989 with the introduction of the FATF by the Group of Seven, a think tank wrote some papers suggesting that that model should be extended. So money laundering should be extended to all crimes. So the proceeds of all crimes, fraud, other forms of human abuse, if you're concealing, moving, transferring, or holding proceeds of all crimes in the 1990s, that required an offense to be put on the books in national governments, and the U.S. government was pressuring people around the world to do this. And then the FATF was used to blacklist, by the end of the 1990s, instead of being an academic think tank, it became more aggressive, came up with the idea of blacklisting smaller jurisdictions. And at first, some of the smaller jurisdictions just sort of ignored the blacklisting until the U.S. Treasury stepped in and said, well, unless you're going to actually enact these money laundering laws and regulations, then you're going to be shut off of the payment system. You won't be able to be involved in moving value around the world through Fedwire or chips. That got people's attention. And then all of a sudden, instead of running an investigation in a smaller jurisdiction, I can recall going into St. Kitts a long time ago in the early 90s, an investigation. I found the registered agent was running a bar, and his records of the various companies he was forming were in a complete disarray with wine spilt on them and beer and stuff, and he had no idea who was the owner of anything because he didn't bother to ask, and no one told him he needed to know at the time. And so it's a radically different situation we have today, and I think it has a lot to do with 9/11 and the problem of regulation of the micro financial problem of terrorism finance supercharged this whole area, and an explosion of interest by the United States and other first world nations, combined with the OECD constantly writing papers about, quote, tax avoidance being evasion, has presented what we have today, which is let's kick the BVI around with respect to its, quote, abuse. And yet when we look critically at what's happening, as a fraud investigative lawyer, I can tell you I do not like to go to the United States to gather records on Delaware companies because there is nothing there. I can't collect anything to identify who stands behind a Delaware company in an apparent massive billion-dollar fraud out of Brazil or of Russia. I have two cases like this right now with Delaware companies. They are silent, they are anonymous. The only thing we can do is identify a registered agent. What do they do in Delaware? They have no records. All they do is receive service of process. Well, the one technique we have is we get the judge to compel the disclosure. Well, who pays for your $200 service a year to receive service of process? Who's paying for your service? And then we find inevitably a New York law firm, then we have a big fight over privilege, and eventually we can maybe find out who stands behind the Delaware company. Same with Nevada, same with Wyoming. And these are far more serious situations for investigation than in the BVI, where we're actually collecting objective data as to who's behind the company, or at least even if that's been falsified by the use of excellent tradecraft in the fraudster corruption industry from Russia, where they have layers of dummy pretend beneficial owners sometimes they use to retard the progress of a fraud investigation. At least we can objectively figure out where to go next in the inquiry. In Delaware, it is impossible, and for reasons that I don't fully understand. When BVI gets kicked around, we get this a small group of people now beginning to look critically what's happening onshore, but nothing's done of it because I'm telling you right now, there are senators in the Senate in America who try and propose legislation to radically change regulation in Delaware, and inevitably there's a very powerful congressional committee from Delaware, and they always kibosh it. Nobody's going to get that legislation passed in my lifetime, I would imagine.
Mm-hmm.
What do you think, Andrew?
I entirely agree. The thing, it's not just whether you have a record of UBOs. There's a big debate in the UK at the moment about whether there should be a public register of the UBO of every company registered in the United Kingdom. Now, I mean, that might be very interesting with every company that's also listed on the London Stock Exchange, where the UBO of every single share would have to be listed theoretically. But more to the point, in the United Kingdom, it's possible to set up a company in 15 minutes online for about £30. I'll ask Bomi in a moment how she feels about that, as somebody who's involved in setting up BVI companies, which are apparently easy to set up for nefarious purposes. If your shareholders are listed as Mickey Mouse and Donald Duck, and nobody's looking because you do this at 3 o'clock in the morning, it's entirely possible that by the following day there will be a company with a valid UK company number owned by Mickey Mouse and Donald Duck, so far as anybody is concerned. And their address, as long as it's a valid UK address, will be the address on the register. And if it turns out to be a small apartment that hasn't been occupied in the last 5 years, well, too bad. It's as easy as that to set up a UK company. Now, obviously, there are random checks, and obviously, if you actually go that far, you may find that people... But if you're more subtle than that, it is that easy to set up a UK company. Delaware, as you heard, there's no record whatsoever. Now, as a fraud, proceeds of crime, asset tracing lawyer, like Martin, what I look for is information that helps you to move along the process. You very rarely find in one place, and with one inquiry, everything you need. And sometimes just the identity of the professional fiduciary in Switzerland or in Guernsey, who is the owner of, let's say, the Nevis company, which is the nominee shareholder of a BVI company, can tell you a very great deal about where that company fits in a picture which you've managed to build up from other sources. Isn't that right, Martin?
Absolutely. Bomi, why is Scotland on our list of onshore tax havens?
Yeah, I mean, this whole debate about onshore versus offshore, I think, is incredibly blurred. And I think that there's a very big misperception about onshore, offshore being sort of, palm-lined sunny isle or, chillier version very close to the UK. And obviously, Delaware is in the US. We know, I was speaking to somebody yesterday who said that apparently it's easier to set up a company in Delaware with less ID than it takes to actually get a library card in Washington, D.C., just to give you an idea. You asked about Scotland being on there. There was an article, I'm going to digress. There's an article in The Economist in 2013 that kind of challenged the notion of onshore versus offshore, primarily because you had the government of Samoa looking to Australia to see where one of its corrupt government officials had set up companies and hid all of sort of some assets from the government, the country. That's Australia. Would you consider Australia offshore? I think it's sort of much more about an offering or how people use a system that is in existence as opposed to a particular place. What I'm hearing on the street these days is that Scotland is becoming very, very popular amongst Russians and other Eastern Europeans to set up Scottish limited partnerships.
It's the new Delaware.
Well, I don't know how difficult or easy it is to create a limited partnership, but in terms of sort of zero tax, the partnership apparently pays zero tax. You do not have to file financial statements. You do not have to have your financial statements audited. And the irony of all ironies is when we started, when Andrew saw Scotland on the slide, he said, "Oh, well, I'm not sure exactly why Scotland is on the slide."
No, he objected to it being on the slide.
Because it's part of the UK, squarely onshore.
No, the point is that what Bomi has identified, Scotland is part of the UK. Scottish companies are part of the Companies Act. But there are differential treatments of Scottish companies for certain purposes than there are for UK purposes, because Scotland in law is a slightly different jurisdiction. There is Scots law with its own courts. And there is a threshold up to which, yes, you're absolutely right, it's not necessary to file meaningful accounts. You file short form accounts, which is essentially a balance sheet, and you don't need your accounts audited up to a certain threshold, which is...
But that's for smaller companies. I think what
but it's
Bomi's
£50 million.
Is pass-through. She's talking about pass-throughs like LLCs, I guess, or partnerships.
Well, LLCs, LLPs are treated in much the same way as registered companies for this purpose. As again, I'm not a tax lawyer, but if you're just wishing to pass through anywhere up to £50 million in a year, this can be a very, very useful...
So,
well, especially if you're not resident in the UK, because you have no tax obligation in the UK.
okay, we're gonna...
I should say that perhaps one thing to help with, the UK thinks a company is a company. In law, it's a separate person from the people behind it. But until it actually wants to do something, so what? It's not until you actually want to open a company bank account that it matters. They don't really think through the problem that might cause elsewhere. And similarly, the idea of a small company not needing to be audited is more that the small company then doesn't have to pay the thousands of pounds it costs for an auditor to audit their accounts, when that might be the difference between profitability and not.
There are three principal lures to the BVI. Tax neutrality we've addressed. Now we're going to move to the second of the three. The second is the BVI legal system. We have the English common law. We have had a dedicated commercial court since April 2009, and until a month and a half ago, it was staffed by Justice Edward Bannister, QC, who was a prodigious worker, who, after a 5-week trial last summer, produced, just on the eve of his holiday for summer, a long judgment in a case that we ran to trial dealing with some Ukrainian issues. And it was a very complex case, and we had many scores of bundles of records for him to absorb and to deal with in the judgment. And he kicked it out in 2 weeks. And it was a consistent pattern from Justice Bannister's. You get judgment within 2 or 3 weeks. 4 weeks for him was a long time. Usually Christmas would intervene to cause it to be 4 weeks. This is very different from what we had before, where in the Eastern Caribbean, you could wait a long time. I recall in 1999, we once waited for a judgment for 2 years. So thank goodness that has been corrected. So justice in the commercial court has gone faster than you have in New York or Toronto. And cogently, we have a regional itinerant Court of Appeal. They're fairly fast too. We get heard within a year, and if you have an urgency, you can get heard within 6 months or so, with final disposition in 7 or 8 months if there's urgency, or a year to a year and a half maximum to be done with the Court of Appeal, and off we go to the Privy Council, which is a pillar to our legal system. The notion that two Chinese businessmen or one foreign businessman and a Chinese businessman can have a joint venture vehicle in the BVI, and if they have a problem with their partnership, with their BVI corporate partnership vehicle, they will have justice all the way to the Privy Council. So there is rationality, some level of predictability, and no corruption in the system. We have a new commercial court judge now in Justice Barry Leon. He's a fellow Canadian from Ottawa, has a very distinguished track record in international arbitration and litigation, and he started off very well. We had a major hearing in front of him recently, and I think we're in good hands passing the mantle from Justice Bannister to Justice Leon. This is a critical piece to the puzzle as to why people are attracted to come to the BVI. And in terms of the legal system, what remedies are available, obviously we have sophisticated companies law with flexibility, which we'll get into in a little while later. But in terms of what is important for fraud investigators and lawyers is we have a comprehensive system to get remedies preemptively, urgently. So in a fraud case, you usually have to move very quickly with alacrity to get remedy. And the first thing we have to do is gather facts. So we can ask our High Court for a disclosure order to find out what's behind the BVI company in terms of ownership information, KYC files, AML compliance files, objective evidence of the ostensible beneficial owner of the company. I say ostensible because sometimes, rarely, in a minority of instances, we get the disclosure order, the trust company complies, we get the records, and it's fairly clear to us when we're reading through them critically that, and it's usually, unfortunately, Ukrainian or Russian case, with the tradecraft being excellent, we'll find that they'll introduce sometimes a dummy UBO into the mix, so we have to do further investigations in order to find out who the true ultimate beneficial owner of a company alleged to be involved in a fraud might be, who actually stands behind the vehicle.
Is that common, Martin, or is that rare? I think that's
in Russian and Ukrainian cases, it happens. It happens in big money cases with racy fraud or corruption. Yes, but it's still somewhat rare. But if you're really involved in hardcore criminal behavior, you're going to try your best to understand how the system works. You're going to know that we have these Norwich Pharmaco orders, and you're probably going to take some evasive action at the point of the BVI registered agent. The other critical thing we have are these ancillary secrecy orders where the judge has the power to seal the record so the members of the public can't look to see what's happening in the proceedings for information. These are basically investigation orders that can be done under secrecy, and the local BVI information defendant, the trust company, is gagged or injuncted from disclosing or tipping off the fact of the inquiry to their underlying instructors or principals. This is critical because if we are chasing value around the world, we need to do so in secrecy so that the other side can take less evasive action than they would if they know how close we are down the value chains to identify assets, freeze assets, and recover them. Andrew, what is the black swan all about from Justice Bannister?
Glad you said it. Justice Bannister, I was about to make a joke about it. Isn't that a movie about ballet? Black Swan Investments. Decision of Justice Bannister from, I think it was 2009? Is that right? Something
Ish.
along that line, yes. It's a problem which we don't have in the United Kingdom because we have Section 25 of the Civil Jurisdiction and Judgments Act, which means that you can go to the UK court and you can get a freezing order, a worldwide freezing order, to support proceedings anywhere in the world. And one common use is proceedings are in the United States. The United States doesn't recognize the concept of a worldwide freezing order. If you can find an asset in the United Kingdom, let us say a nice house in Kensington, it's strange how that keeps coming up as a random example, you can apply for a freezing order on the back of identifying that asset in the UK that applies around the world against your defendant in the American legislation, in American litigation. Not so in the Caribbean. You need to be able to identify a cause of action against the person whose assets you would like to freeze. Now, Black Swan were a company that bought up distressed debt. And they wished to pursue an individual in South Africa. In something equivalent to fraudulent trading for the company, to make him liable for the distressed debt that they'd bought. They didn't, however, get a parent freezing order in South Africa over his assets, making him subject to an in personam obligation not to deal with his assets. Instead, they came to the BVI and said, we would like to freeze the assets of that company, which we think is, I can't remember the name of the South African gentleman, but we think it belongs to him, and even if it doesn't belong to him, the company belongs to him. And Justice Bannister, after much debate, concluded that actually the courts in the BVI do have jurisdiction to make an order like that.
To preserve assets pending trial elsewhere for judgment, right?
Yes, for money judgment, which has now been expanded in a UCOS case. The purpose, as I say, this isn't an issue in the United Kingdom, but the difficulty was, in order to get a remedy against the BVI company, it was necessary, theoretically, to show that the BVI company itself might become the subject of a claim. But there was no claim against the BVI company itself. It was against South African gentlemen. And that has been the cause, I understand, of much debate around the Caribbean.
Isn't this the Chabra jurisdiction where the court has the power to freeze assets controlled by the defendant?
And Chabra is an English case. Mr. Chabra was an Indian gentleman who had no intention of paying the judgment debt entered against him. He was not officially the owner of, but patently in control of, companies that held substantial assets. Now, a Chabra order, for those who don't know, is a freezing order that says the company will never be the target of litigation. We do not accuse the company itself of wrongdoing. But the company is at least arguably holding assets which belong to the defendant of the actual or intended litigation.
Well, they're controlled by the defendant.
In one form or another.
Defense counsel constantly argue, no, The assets do not belong to the shareholder.
Yep.
They belong to the company. You've got no cause of action against the company. Why are you freezing the company's assets? And Chabra is the response that if the primary defendant in a fraud case is controlling a company, a single-man company with one shareholder, court has jurisdiction to block its transfer of those assets because the company might be used as a vehicle to defeat the freeze order. That's the principle.
That's the essence of the Chabra jurisdiction.
But
and that's been, sorry, Martin, that's been made a lot easier by by one decision.
Now, moving on,
Court.
because we have only 14 minutes
Yeah.
to go,
But
we have
look up Prest and Prest, which will help you with the Chabra and Black Swan jurisdictions as to why you can come after companies.
So we basically have, Black Swan is a satellite freeze order. Before we'd have to start a full plenary action in the BVI, because it was thought that the court had no power to freeze assets without a main proceeding being there. But now we have this Black Swan idea. So the point about it is that the court is ingenious at times to find ways in the law to properly provide preemptive remedies to right wrongs. We have now a new arbitration act, an arbitration center, and we have invited the UK government to allow us to be a party or to accede to the terms of the New York Convention on the reciprocal enforcement of foreign arbitral awards signed in New York, I think, in 1958. A critically important international convention. We don't have one for judgments. We have one for arbitration awards. So one of the greatest advantages of arbitration is once you get an award, it's very rarely you have a right to, the other side has a right to appeal. And secondly, you can get these awards enforced around the world very, very quickly or relatively quickly compared to judgments, because there's an obligation on I think over 140 countries' part to honor these awards. Now the BVI is signed up to this construct, and we can have arbitration in the BVI and have other countries recognize our awards. This is a new development in the last year. The third pillar to why people seem to come to the British Virgin Islands to form companies and to use our financial services sector is privacy and confidentiality. This is the perception, the apprehension that people have. And to clear up some misunderstandings, unlike Cayman Islands, Bahamas, St. Kitts and Nevis, Switzerland, Liechtenstein, we don't have a statutory penal law that says, with one exception I'm going to come back to, which is new, to do with computer crime. We have no sort of bank secrecy or company secrecy legislation. Information that's private and confidential is protected by the common law rules that are centuries old, where in a agency relation, like a registered agent or trust company forming a BVI company, they're an agent for a principal, usually the shareholders of the company, and they have duties of confidence imposed by the common law not to disclose private information dealing with that relationship. So the identities of the directors, the shareholders, are confidential in that common law recognized relation. And the consequences of breach are the old common law principles. The principal could sue for an injunction to stop the improper use of the confidential information or sue for damages. That's it. There's no, you'd go to jail by disclosing the information to a third party, with the exception of a new statute that was enacted a year ago as a result of the controversy dealing with the leak of data housed on 2 hard drives, I guess.
Before you go on to that, sorry, Martin. I mean, I think on the privacy and confidentiality issue, I think one of the big key things to sort of first say is that privacy and confidentiality is not analogous to secrecy. They're completely different concepts. And I mean, within the BVI, coming from a compliance kind of due diligence background for regulated entities, registered agents who have to compile this information, there is a lot of due diligence that those companies have to get. They're required to get identification and verify the identities of all shareholders, all directors, all beneficial owners, actual beneficial owners. If any nominees are used, they're required to actually have agreements in place that show the link between the nominee and the actual ultimate beneficial owner. In addition, you're supposed to have addresses and verification of addresses. Now, although this isn't public, So sorry, this goes back to what you were asking me. How do I feel when you say, oh, you can set up a company in 15 minutes in the UK? You definitely cannot do that in the BVI because of all of the checks that need to sort of actually go on and the verification of that. And although those registers and that information is not publicly available, the registered agents are required to have that on their books or have access to it immediately for law enforcement authorities and regulators should they request that information. But there are legitimate reasons. I mean, we're not naive, right? So we understand that in other parts of the world there is political retribution, that there are safety and kidnapping risks, that some governments have been known to unlawfully seize private assets.
Well, one could argue that there's a relationship between human dignity, freedom, and privacy, that they intersect. Yeah. That the human dignity means you cannot countenance the state in your bedroom or arguably your bank account or behind your company unless there's a good reason. I would say to the Guardian newspaper in London, no, you don't get to know everything that's going on in someone's bedroom or their bank account or their BVI company. Just because you want to write an article and sell newspapers, it doesn't mean you get to invade people's privacy without license, without regulation, and then therefore limit their freedom and their dignity. So there is a serious argument that can be made in the favor of international human rights for why you have privacy and confidentiality. Here I am, a serious fraud lawyer who fights corruption and fraud and abuse. And I understand I have rules to follow. I can't just go and take people's assets. Their defendants are entitled to due process and fairness. It's frustrating for my clients and me to have to deal with these rules of fairness and due process. But guess what? That is the rule of law. And if we're going to live in a civilized place, we have to follow the rules. And the newspapers have to recognize that instead of just criticizing, oh, because you've got confidentiality and privacy, that's intrinsically evil and bad and wanton, and it should be stripped aside, and there should be all public about everything to do with these companies. I object to that on the grounds of fairness and human dignity.
Andrew, sorry, I have a question for you about privacy. Your chambers does quite a lot of international human rights and work, doesn't it? So, I mean, on this issue of privacy and confidentiality, is that something that's described in kind of EU declarations or what was it?
Right. Firstly, the UK is the home of the absolute bugbear of some of the people at this conference, known as the super injunction, which is an injunction that not only prevents a story from being published, it prevents anybody from telling anyone in the world that there is even an injunction in place preventing the story from being told. Let me give you a very simple parochial reason why you might want some privacy using a BVI company. Suppose you are a high-profile celebrity, and you buy, with some substantial assets, and you buy yourself a yacht. If that yacht is in your name, or there's a public register of the company ownership of that yacht, every time that yacht goes for a sail around the Caribbean, every pirate in the Caribbean has some, and there are quite a few still, knows full well that that yacht is one worth targeting because the person on board it is likely to be extremely wealthy with a number of people who are likely to pay a very substantial ransom. There's a good reason for privacy in and of itself. The direct answer to your question about the European Convention, yes, Article 8 of the European Convention on Human Rights enshrines the right to privacy of life, home, and that has been taken to mean, as Martin says, the bedroom, the bank account, your front room, everything. So unless there's a good reason for invading your privacy, then the courts of the United Kingdom and indeed throughout Europe say, sorry, keep your nose out, to put it bluntly.
Now, we have limited time. I just wanted to cover one other point that's not on the slide, dealing with privacy and confidentiality. Remember I said there was no penal law in the BVI protecting information, it was only common law protected. Well, there's one exception to that is this new Computer Misuse and Cybercrime Act of 2014. It was enacted in response to computer hard drive data from, I guess, Portcullis and Commonwealth Trust Companies, BVI, and I guess Portcullis in Cook Islands for information was reposed on the server. We suspect that a third-party cloud service provider for these two trust companies had an employee who purloined the data, and all of a sudden it got dumped on the desk of the ICIJ in Washington, the International Consortium of International Journalists. They then took all this massive data, over 10 years of detailed data dealing with ownership of BVI companies from these two offshore trust companies, and split it up. So if there was data dealing with India, it went to some Indian journalists, Canada, it went to the CBC, Great Britain, The Guardian, of course, and on and on. And they wrote scandal pieces dealing with attributing the ownership of BVI companies perhaps with public servants who perhaps should not have many assets. You could argue there was a public service in the revelation of some of this material. You could argue that the privacy rights we've been describing are very important to guard against. Our Legislative Council responded with the statute saying that if you know or ought reasonably to know that material was taken from a server on a computer dealing with BVI companies, that and you publish that material, knowing or that you should know came without authority, then that's an offense, and there's some serious sanctions ostensibly in the statute, up to $500,000 of fines, 15 years in prison, and what have you. When the statute was first proposed, there was a big debate globally about it, and a public interest exception was put into the statute so that it's perfectly acceptable under the law to publish this material if it's in the public interest. It's a defense that can be raised. So this is a new thing we have dealing with the protection of information. Also, there's provisions dealing with pornography being a defense to using computers and what have you.
I think anecdotally, the ICIJ thing, I don't want to go down the route of that because it's been discussed ad nauseum, but what I find interesting is that for all the talk about in the press about the BVI, and quote, people alleging having the misperception that it's an island that promotes secrecy and everything like that. The reality of what the ICIJ leaks show is that the BVI system works because the information was there to be had.
Yes, it does.
If the BVI wasn't actually collecting shareholder, director, UBO information, there would have been no story.
Well, it supports this next slide. Bomi is right, because the data is collected and it is available for law enforcement, revenue authorities, fraud investigative lawyers using judicial measures. And in order to assess what's actually going on, you need to actually look at the information that's available, and it's very extensive. And the methods available to get it. I guess we have limited time, one and a half minutes or so. Could I invite any questions that you may have in the audience? No questions?
It's amazing
Okay.
how being just before lunch can have that effect.
A question.
Yeah.
Yes.
Thank you. This is a question for Andrew. You had mentioned Preston Prest.
Yes.
And I was just interested to know how that has changed, if anything, the
Yes.
issue of reaching behind the company and the assets of the company.
Well, for those who don't know, Preston Prest is a divorce case. And Mr. Prest lived in a very nice house owned by a company. He seemed to be able to have indefinite access to all of the assets of various companies, but he didn't own a thing. And in fact, the companies, when one traced through the ownership, it transpired that Company A was owned by Company B, which was owned by Company C, which was owned by Company D, which was owned by Company A. Now, this all went up to the Supreme Court, and Lord Sumption severely restricted what we were starting to understand as the doctrine of piercing the corporate veil, and said that you can only go behind the company, as you put it, properly, in one of two situations. One is where the company is being used as a shield to hide the fact that there are individuals acting, so the company being used as a vehicle for fraud, for example. And the other is where the company is created to evade an existing liability. The classic example is an employee who has a non-compete clause in their contract for, say, 5 years. And so they set up a company doing what they're not supposed to be doing by their contract. The court said, well, we'll go through the company to say that that individual is breaching their contractual obligation. But Lord Sumption said, well, other than that, Salmon & Salmon has stood for the, well, what is it now, nearly 200 years, and it remains the law that companies are separate entities, as I said at the outset. But, companies are just like people in the sense that they are entities which hold assets. And this comes to my comment about why Preston Press may increase the Chabra jurisdiction in particular. And if the facts are such, then there is no reason to suppose that a company is not holding assets on trust for someone, just as there might be said that an individual is holding assets on trust for someone. So yes, the shares in the company may be held by a nominee, but if the facts are such, it can be abundantly clear that the company is holding that house, that yacht, that bank account on trust for the individual who appears to be able to access it at will and without hindrance from the board of directors.
Andrew, did this idea come from the family division of the High Court?
Well, no, the family division was increasingly just ignoring the corporate veil, or corporate identity, and that was the problem. What happened was that the companies came with commercial lawyers, and the case ended up in front of a court of appeal consisting of commercial and chancery judges and a family judge, and it split along division lines. The commercial and chancery judges said, no, you cannot treat the corporate identity in this way. Companies are companies. And they were thinking about the bigger picture. And the family judge was saying, well, this is ridiculous. We can't have people evading their obligations to their spouses. And the same is true in the criminal arena, where almost there's a separate branch of law emerging, because there's a fear that people can simply incorporate their criminal activity and evade any sort of confiscation process. When it went up to the Supreme Court, it was almost like a clash of these two doctrines. And this was how Lord Sumption, I think, squared the circle. And I think it helps the fraud investigators as much as it helps the family division.
So in commercial cases, we can argue now that the assets reposed in a BVI company owned by a primary defendant to a fraud case, you could argue that those assets are held in trust for the defendant?
Yeah.
Based on this family law case?
Yeah.
Interesting. Thank you. If there are any more questions? No? Okay, well, thank you for your attention this morning.